Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every 2 weeks, community conference call. The questions that we answer are based upon the facts presented. This is not a substitute for a detailed legal consultation. As you enter the conference, you are told in the recording, this is not a call that establishes attorney-client relationship either. We are doing the best we can to provide you whatever information we think applies to these cases. That said, I'm going to begin as usual with the questions I have marked as frequently asked questions. There's a whole bunch of them today, actually. Either I think many more questions are being asked, therefore a lot of questions are becoming frequently asked questions, or there are areas of law that have been upturned by the Trump administration and we are still all struggling with the impact of them. So either the policy is changing too fast, or maybe we have many more questions, but there is a whole lot of frequently asked questions. First one is from Rick. He's on a cap exempt H-1B working for a non-profit. Somebody filed a cap subject quota H-1B, got an RFE, and was denied with a reason for maintaining of status. They asked my pay stubs. So the question is, will there be an impact on my current H-1B? So this question, folks, is a little difficult to answer. I get asked this question, will there be an impact of a denial of an H-1B on my existing H-1B? If it's a transfer or an amendment or even an extension? And the answer is, if the denial is not related to your current H-1B status. So if they deny, for example, a second application by another employer, this is not specialty occupation, that has no effect on your existing H-1B. But here they are talking about status. So when an H-1B, a subsequent H-1B is denied because they say you're not maintaining status, we are looking at a totally different ballgame. So while the denial doesn't affect you, the fact that there is some doubt about your maintenance of status, that can be a problem. So will there be any impact on my current H-1B? No, not if you are maintaining status. Number two, if they only ask for pay stubs, can I submit them and file an MTR? If the case was denied just for maintenance of status and you have the pay stubs that are required, then there is a very high likelihood the case will be reopened. If the petition is denied, then you are still subject to the H-1B quota. Let me just make sure that everybody can hear me okay. I forgot to check.
The conference is now in conversation mode.
Are you all able to hear me okay, folks?
Yes, we can.
Yes. Okay, good. Thank you. Okay.
The conference is now in presentation mode.
So this was the frequently asked question related to impact of denial of an H-1B on a current H-1B. Does anybody have a follow-up question on this? If yes, press *5 on your phone. No new questions. Any follow-up question on this topic? Okay. We have one from New Jersey. All right. Yeah, New Jersey, go ahead, please.
Hi, Rajiv. This is my question I posted. So, like you said, questions here are, I'm on a cap exempt H-1B right now.
You don't have to repeat the facts. I already have the facts. Just ask your question.
Right. So, will there be an impact on my current H-1B? So, on the RFE, they gave me different questions. They mentioned one is the maintenance of status, the other is the specialty occupation, the other is the new employer's employee-employer relationship, and also the employer's documents. So after responding to the RFE, they gave me a denial notice just based out of one reason, saying that It's payroll records, change of employer, and then they said the maintenance of status and asked me to submit all my pay stubs and W-2s, which I did submit and reopened the case. So in this situation, I'm expecting that my current H-1B is not in danger.
No, it certainly doesn't look like it, because whenever you
Okay.
have a denial based upon a limited ground and that limited ground doesn't affect your current status, you'll be fine.
Okay. And I did submit a motion to reopen up with all my pay stubs and W-2s.
Mhm.
Do you know from your experience, would there be another RFE if they don't seem those sufficient, or would they directly deny the case
Very
going
unlikely, but
forward?
not impossible. There can always be other
Okay.
RFEs, but usually they don't send RFEs after an MTR, not necessarily. Okay,
Okay. Okay.
good
Sounds
luck.
good.
All right, bye-bye.
Thanks.
Going on to the next frequently asked question. So this is about somebody on H-1B joining another employer while a transfer, extension, or amendment is pending. So this situation comes up quite frequently. Let's say you have an extension going with employer X, and while that extension is still pending, you have employer Y applying for an H-1B transfer, or even after that, employer C, while these two cases are pending. So all of these transfers are possible, but there are certain rules. The most important rule to remember is that your strongest protection is a valid initial case. So if you are working for employer X and you have approval till 2022, and yesterday you applied for transfer over to employer Y, and a week after you applied for a transfer to employer Z, but your original X petition is still alive, that gives you a lot of protection. If any of the subsequent cases are denied, you could go back to work for employer X even if you have changed employers, or you might even have a 60-day grace period to apply for another case. So your strongest protection is the original approval. USCIS has given some weird answers to us over the last couple of weeks that say if the old case is withdrawn, the I-94 is no longer valid. This was in relation to an I-9, filling an I-9, an employer's question. Nevertheless, it's always best to double check with your lawyers what the current thinking is. You see, folks, the problem is regulations and laws take a long time to change, but policies many times can be changed overnight. So, and Trump administration has been very inconsistent. It's best to check what the current thinking is. The question I have is from Harish Kumar. He says, resigned company A already got an offer from employer B, applied for H-1B premium. We have an RFE, but I have another offer from C, who is yet to file. If RFE is denied for B, can I join C with the receipt? As employer C has started H-1B transfer, the answer is yes. How long one can stay in US without job or payroll having H-1B? It depends. Normally, 60 days grace period is available for unexpected cessation of employment as long as your I-94 is valid. But let's say your I-94 is valid for only 45 days. You will not get a 60-day grace period. You'll get a 45-day grace period. Star 5 if you have any follow-up questions on this frequently asked question. Star 5. Nothing new. Any new questions? Any follow-up questions? Okay. Let's go on to the next frequently asked question. So this is also, I have discussed this issue several times, but I feel like it bears repeating. You become H-1B cap exempt only either when your H-1B change of status is approved or when your H-1B visa is stamped if you're coming from outside the US. So let's say you are outside USA. We've received your H-1B approval, we sent it to you, and you did not apply for an H-1B for 6 months. Because you haven't applied for a visa, you are not yet exempt from an H-1B cap. So if you want to transfer to another employer, you won't be able to do it. That's the USCIS thinking. I think they are wrong, and I think somewhere along the line they will lose a lawsuit over this. But currently that is how they believe. Unless you get the visa stamp, if you're outside, you are not cap exempt. If you're inside USA, if you don't receive change of status, you actually don't get a change of status to H-1B. You are still cap subject. So at present, I'm working in OPT. I have an unused stamped H-1B, which I got in August 2013, and my visa was stamped on August 2014, a year later. I never traveled with H-1B, so ultimately that H-1B transferred. I think you are exempt from the H-1B quota, unless the government, which it does many times, changes their policy overnight. Because you got an H-1B visa stamp, even though it was a year later, you should be okay. There is another interesting problem. The problem is the law exempts you from H-1B quota from 6 years of approval. So in other words, if you have been approved for H-1B any times in the past 6 years, you are exempt from the quota. So in your case, dear Sharma, that's the name, Ishan. In your case, Ishan, if we counted from 6 years from August 2013 when your H-1B was approved, you are then okay or cap exempt till August 2019, right? 6 years. But again, the policy has been that they count the 6 years from the date your H-1B expired, which is 2014, not 2013. Policies can change overnight. So I think you can apply for an H-1B exemption as an H-1B exempt worker. *5 if you have a follow-up question. No new questions, only follow-up questions, please. Okay. So let's go on to the next frequent. There's a lot of frequently asked questions. So what if you have some past immigration problems and they are causing a current visa denial? I have many cases like this. So in this case, what happened was this Abhishek had been in a fake university for 1 year, and then he moved to Canada. Now they are not letting him come. They are saying you were a part of the fake university. So what are my options? He was just trying to get a tourist visa. Should I give it another shot, wait to become a Canadian citizen, then apply, or go through a conference, etc., hire a lawyer? I think you should hire a lawyer. The reason for that is, typically what your lawyer should do is, first they should reach out to the consulate or wherever the visa was denied and ask them what was the reason for denial. At the same time, they should apply for Freedom of Information Act request, get a copy of all the documents that the government has on you. And it's a long, tedious process. It could take months or even years to get it straightened out. So far, I think we've done 3 cases like this successfully in the last year or so, where somebody was getting denied visas because of past immigration problems. So it is possible to fight this out. And it's not rocket science. It doesn't require the best lawyer in the world to do it. It just requires a lot of slow grinding work, because many times I will write to the consulate, they will respond with a meaningless answer. I have to go back and say this answer doesn't make any sense. It's a boilerplate. So it can go on for a year and a half. But eventually, if there is nothing against you of substance, there certainly is a good possibility you can extract yourself from this situation of blanket denial. You should also look at, if possible, if applicable, something called a 212D as in doctor 3. 212D3 waivers. These are available for non-immigrant visas, such as a tourist visa, even though you have some kind of a bar, 3-year, 10-year bar, or a permanent bar. from entering the United States. Star 5 on your phone, please, if you have a follow-up question on this. Star 5. Okay. So this is another case which I have. Oh, there is a follow-up question. Let's see. This one is from Canada. Canada, go ahead. We can hear you.
Yes. Hi, Rajiv. Just a quick question. If I need to hire a lawyer, would you recommend somebody based in Canada or US?
I don't think it matters because it doesn't require a trip to the consulate. It requires correspondence with the consulate. It matters not, no matter where the lawyer is. Okay?
Okay, great. Thank you very much.
You're welcome. Good luck. Okay, so this one is also very common, which is downgrading from EB2 to EB3. I think I have discussed it like 3 or 4 times already. What has happened is for Indian born people, EB3 is faster than EB2. So if you already have an EB2 I-140 approval, what should you do? So my answer to that was, I'll give you the short version because I've discussed this in detail, I think last conference call and the one before that also. The quick answer is, I see no problem applying for an EB3 and then using whichever one is faster when the time comes. Can you go back to EB2? Absolutely. I don't see any problem with that either. So does it make sense to downgrade? I always do. Can I use EB2 later on? Yes, of course you can. Either one is fine, even because one approval doesn't overrule the other. If it did, you wouldn't be able to apply an EB3, right? So they can both live simultaneously. I don't see any problem with it. Star 5, if you have a follow-up question on this, star 5. Okay. Let's go on to the next frequently asked question. I'm pretty sure there's one at the bottom. Yes. So this one also comes up quite a lot. If you are not India born, if you're India born, Ravi, and even your spouse is India born, then applying for a green card while as a student doesn't help you much because it's not going to get you work authorization, nor is it going to get you a green card for another decade plus. But if you were born in another country, any of the countries that are not packed up, let's say you were born in UK, then applying for a green card while on student visa if you don't get selected in the H-1B lottery is certainly a possibility. I don't see why not. The only thing is, try not to travel when you're in that situation, because remember, F1 is not a dual entry visa like H-1B or L1, where you can have the intention to have a green card and still be okay with your non-immigrant status. Okay. So star 5 if you have a follow-up question, star 5. Okay. So in theory, this is available, but if you are India born, maybe not such a good idea. Okay, I'm going to get started on the regular questions now. We just answered the frequently asked question. And if time permits, then I'll take new calls. Okay, let's start the regular questions. So this is question number 7, IMM.SS. I have an approved I-140 in EB2, priority date of 2016. Got an EB1, but the old priority date was not retained. We have raised 2 service requests. They have not responded. That's not a problem at all. Not a problem at all. Because by law, you are entitled to that EB2 priority date. They can't keep it from you. So whenever the dates are current, just apply for your 485 and include both your EB2 and EB1. EB2 for your priority date and EB1 for your approval. No problem at all. So don't worry so much about it. Star 5 if you have a follow-up question. Star 5. Okay. So let's see. This question is from... Oh, that's odd. Oh yeah, here it is. From Illinois. Okay. Just a reminder, no new questions, only follow-up questions on what I'm discussing. Illinois, go ahead, please. Illinois?
So what I was told that if we use both the I-140s like EB2 and EB1, it would be rejected at the mail room because they don't know.
That's ridiculous. That's ridiculous. I don't agree. Okay, because we have done it many times, never had any problem.
So that's a possibility, you're saying?
That is the most likely way to do it.
Okay. All right. Thank you so much.
Oh, you're welcome. Good luck.
Thank you.
Okay. Andy says, my wife's 485 and mine are pending based upon approved EB2. My wife was able to get EB3. How can we interfile to use my wife's EB3? You cannot. Oh, okay. I'm sorry. Maybe what you're asking me is, your wife's and your I-45 pending based upon my approved. Yes. So you filed your 485, both of you together, based upon your I-140. Now her date is current. How can we use this? And basically the way this works is you contact the USCIS by mail as well as by voice. Have your lawyers do that and ask the government to convert her 485 to primary, yours to derivative, and use her I-140 as the basis for approval. I don't see any problem with that. We've done this before. Okay. USCIS is not willing to listen since our date is not current yet, but your EB3 date is current. And if it is such a big deal and they are really causing a lot of problems, the practical solution is just file 2 new I-485s, she as the primary, you as the derivative. It's a loss of money, but at least it will save you time, and include in that the same A numbers that you used in the prior case. Attach an explanation. That's why you are filing a second set of 485s, because the first ones did not reflect the way you wanted to go. I think that should be fine. *5 if you have a follow-up question on this, Andy, or anyone. A follow-up question. This is from my neck of the woods, Washington, D.C. Washington, D.C., go ahead. We can hear you.
Yeah, hi. This is Andy. Hi, Rajiv. First of all, I would like to thank you for the free service you provide.
Of course.
So in this case, I did email them and mail them and all that stuff, and they just they said, "Oh, your date's not current." The thing is, I was wondering, should I use the word cross-chargeability rather than interfiling?
No. This is not cross-chargeability. Cross-chargeability would be if you are born in India, your wife is born in France.
Right.
That's cross-charge.
Right.
This has nothing to do with that. What you are trying to do is convert your primary 485 to derivative, her derivative 485 to primary, and then use her I-140 as the basis for approval.
Right. So I don't need a lawyer for this, right? I mean, I can just open an SR, say that the case is beyond processing time.
You probably can. This is not legally complicated. This is fairly straightforward.
It's just a mail.
Yeah. I don't think.
But there are multiple ways, like make a phone call or open an SR saying the case is beyond processing time.
That's exactly.
Or go through the.
That's exactly what we would be doing. It isn't. There isn't any black magic in this.
Okay, and is there anything to do with ombudsman? That's
See,
nothing to do with that,
ombudsman is. I don't know if you remember. In India, there was a big movement for Lokpal. You know what Lokpal is?
Mm-hmm.
Yeah. So the idea is it's a watchdog agency that sits outside the agency, even though it's a part of the same agency. So even though the Office of Ombudsman is a part of the DHS setup, they sit as a watchdog to make sure that USCIS behaves itself. So ombudsman helps when you cannot get a legal right addressed through the agency. So if you made this request and they still didn't convert the 485s, you could then approach the ombudsman and open a case with them.
So, but I've already, so they responded that it's not current, so I've already done that once.
Then you contact the
And,
ombudsman's office, open a case. You can do it online. So just type USCIS ombudsman. The moment you type that in a search engine, that page opens up. Okay.
But would that be a faster way than, redoing the whole thing, the SR and all that? Ombudsman?
There's nothing that stops you from doing both.
Okay.
Okay. All right.
Okay. Thank you so much.
Good luck, sir. Okay. So this one is from PO Box 8284. I've applied for 485 using cross-chargeability. I've been waiting for 10 months. You mentioned I can reach out to congressmen. I can't really do anything besides that. Is it okay to reach out to congressmen if I'm within normal processing time? And the answer is they probably won't do anything if it's within normal processing time. They, as in USCIS, they'll just tell the congressman that the case is well within its normal processing time, etc. So yeah, you should file a mandamus? No, mandamus should not be lightly filed. Mandamus case should be filed only when there is a real reason for it, where your 485 has gone quite a way beyond normal processing time. And even then, remember, a mandamus can only get you action. It cannot get you favorable action in these cases. So don't think that if you win on mandamus, you will win the case, your green card. All you will win is a right to a decision. And that decision could be yes or no. So I would file a mandamus only if we are desperate and nothing else is working. *5 if you have a follow-up question, *5. Okay. Next question is from Ganjan. This is a EB5 investment-based case. Their I-526 was approved. What are the next processes? So basically, if you're outside USA, you will be eventually called for an interview at the consulate, then given a conditional green card approval, and there'll be some directions on what to do with that. You land in the USA. Within 2 years, within 2 years of the approval, you have to apply for removal of the condition. That's a separate set of forms. So that's the typical methodology if you're outside. If you're inside USA and the dates are current, whenever they are current, you file for I-485. Once that's approved, you have a temporary green card. The same 2 years, you have to apply to remove the condition. If I'm issued the I-5 visa and I want to apply for re-entry permit, how long can I stay out of US? No, I don't think you're talking about a re-entry permit. If you're talking about green card, if you don't maintain your permanent residence, you can lose your green card. So there's no easy answer. There are too many variables for this. I would suggest please talk with your lawyers who processed your EB5. Do a detailed one-on-one consultation with them. And yes, re-entry permit is a multiple entry document. You can enter and exit as many times as you need to within that duration. *5, Ganjanji, if you have a follow-up question, *5. Okay. And this one is from India. Yes, India, go ahead. I can hear you.
Hello, sir.
Hello, Ji.
As you know, my case was reaffirmed by the USCIS. So, is there any possibility that they may just ask us to submit the passport and they'll directly stamp the visa?
Are you Ganjan? Are you talking about this case? What are you talking about?
About my case.
I don't know what's your case.
I'm Gajan. Yes.
Oh, you're Ganjan. Oh, you're Gajan.
Gajanan.
Sorry, Gajanan. I'm sorry, I mispronounced.
Yeah.
Okay. So you said your petition was reaffirmed. So basically the consulate denied. The case went back to the consulate. Now, denied, it went back to USCIS. Now it is sent back to the consulate with an approval. Just have to make a visa appointment date, I think.
Okay.
Okay. So you just have to reapply for visa. Yeah.
We have to follow up with the consulate for that, or the consulate will contact us.
They won't contact you. They won't contact you. My experience so far has been that you have to set up an appointment with them. I don't recall whether you're required to pay the fee again or not. That's something you can follow up with the consulate, but you have to initiate some action. Okay.
And what does the courtesy notice means? Like USCIS sent us a courtesy notice informing that the case was reaffirmed.
Yeah, the courtesy
So
notice.
will I again receive some another notice?
Yes. By the way, if the case has just been reopened, I don't know what that means. Reopened simply means they are looking at the case again. So, but if you say it was
Reaffirmed.
Oh, it was reaffirmed means it was already approved again. So basically, what this means is consulate raised some objection. Case went back to the USCIS. USCIS may have issued your lawyers a notice. They responded to it. The USCIS thinks that the case is fine. It should be approved. So that is reaffirmed. Once that's reaffirmed, the file gets back to the consulate, and you should be making another appointment. Okay.
And how much time does all this process
I
take
do not
to
know.
again get an
I do not know the answer to that question. Too many variables.
Okay.
All right. Good luck.
Okay.
Bye-bye.
Thank you.
Okay. So next one is from Vijeta, extension of stay on B2 visa. I'm working on H1B. My mother is visiting me. She came in February, going back in August. I want to extend her stay by 4 months. So you folks can visit some more places and consult some doctors. We don't have any planned surgery or hospitalization. Would these reasons suffice? So I think the reasons are going to be irrelevant. Why irrelevant? Because if you ask for a 4-month extension, plan on leaving in that 4-month period, the case may not be decided. The case takes 6, 7, 8, 9 months to decide. So you should be leaving within those 4 months and keep copies of all these documents about having asked for an extension. The reasons may not come into question, but they should be truthful, whatever the truth is. Only problem is when you applied for an extension, subsequent entries, government can ask extensive questions about your reasons. And don't come back for at least a year after you leave in these circumstances. *5 if you have follow-up question. *5. Okay. Let's see. This one is from Florida. Yes, Florida, go ahead. We can hear you.
Hi. So I have a second question. So what happens that while she is still here and suppose we get a denial? Like,
she would have to
what
leave.
happens in that case?
She would have to. It's very unlikely because they are taking a good 8-9 months to decide these cases. But if she's here and she gets a denial and she's past her initial authorized stay, she should be leaving within the next few days as early as she can.
And does this affect her B2 visa, the 10-year visa that she has?
It should not. Also, make sure she doesn't come back for at least 1 year after she leaves.
Yeah, so this wouldn't void her B2 visa, right?
It does
my
not.
main concern.
No, ma'am. It does not.
Okay.
Okay.
Okay. And so even if there is an approval, does it still result in extensive questioning at the Board of Entry in future?
I don't know about extensive, but it can still lead to questions. However, if you have the approval as well as the initial application that you filed, you should be okay. All right.
Okay. And even in case of denial, I know that there can be problems, but if we come after say 2-3 years, it should be fine, right? In your
I
opinion?
think so. I think even after a year, it should be okay.
Okay. And it says that they recommend to apply 45 days in advance, but is that a hard and fast rule?
No, it isn't.
Okay. Thank you so much.
You're welcome. Then this question is from Kumar. So my H-1B transfer got denied from employer A to employer B. Denial notice June 13th. Will I be out of status from June 13th? Or the date we receive the hard copy, June 13th onwards? Because it can be 7 to 10 days to receive the notice. This is one of those practical problems with non-real-time communications. Between the violation of status and your notice of it could be quite a while. So assume that it starts from the date of the denial. Your I-94 is good till 2020. Is there any advantage? I think it gives you a 60-day grace period. I do believe so. And again, please talk with your lawyers. Like I said, USCIS has been making some weird noises about if the old case is revoked, then you no longer have the I-94, then you don't have the 60-day grace period. I don't know the answer to that change in policy. That's something your lawyer should follow up and check on. Third, can we refile the H-1B? You can, but you could be running both unlawful presence and being out of status. So you could do premium processing and see how it works out. And it should not affect your future H-1Bs. It can have an effect on student visas and tourist visas, but not for H-1B. Can I start working on the receipt notice legally? And the answer is, depends. If you're covered by the grace period, yes. So your lawyers have to make that determination. What are the consequences if H-1B approves in consular processing? If you have a previous stamp and you get an approval with consular processing, theoretically at least, you could travel outside, just go to Canada or Mexico, and return back using the 2020 visa and the new approval. You shouldn't have to go back to the consulate, theoretically at least. *5 if you have a follow-up question on this. *5. No new questions, please. Only follow-up questions. Okay. So this one is from Texas. Texas, go ahead, please.
Hey, Rajiv.
Hello.
Kumar here.
Yes, Kumar, go ahead.
Yeah, the only thing is, like, my employer, said they already started, they're going to send the documents today itself for premium processing, and then they are requesting for extension of stay too. So they're requesting for both I-94 requesting.
Right.
So in that case, they said they can legally work on receipt notice.
I think
because they say they're in two cases. Only 60 days grace period, or they're going for non-drunk H-1B. That's what they're looking for.
Look, I don't want to answer this question because I have to really review the whole case, sit with you. I can't really comment on this. I would have to definitely take your lawyer's word for it. There are some variables here that we can't really cover in a 3-minute phone call. So would a 60-day grace period be available? Theoretically, yes. What if the old H-1B is revoked? I think it should still be available. But like I said, USCIS has been making some noises about that. Okay. So you can if your lawyers are competent, I see no reason why you should not take their word for it. Okay.
Okay. Thank you.
You're welcome. Okay. So Karthi wants to know, I know that I have to work outside USA for 1 year to be EB1C eligible. If I start a new job with US as a manager and then serve 1 year outside USA, will I be qualified for EB1? Why not? The law only requires that you must be outside USA for 1 year as a manager. or a specialized knowledge employee, depending upon what you're looking for. It does not prohibit you from having a managerial job in the meantime in the United States on something like an H-1B approval. Okay. Star 5 if you have a follow-up question, star 5. Nitesh wants to know, is software engineer and data engineer same or similar? Normally, I would say yes, because some of the requirements to qualify for a software engineer and a data engineer are the same. So in my opinion, these are same or similar jobs. Star 5 if you have a follow-up question, star 5. Siva says, I'm currently working in company A. Company B is going to start the change of employer. I'm interviewing with company C. And the answer is all of this is possible. I've discussed this several times today. Figure out the details with your lawyers, but A to B to C and having all the cases pending or some of them pending, all of that is possible. Star 5 if you have a follow-up question, star 5. Okay. Nuandra says, I'm working on EAD with AC21. Travel out of USA when switching jobs or on no company. No, you should not travel if you don't have a job offer. So if you are transferring companies, it's okay to travel as long as you have support and verifying letter from the company. Having a job offer is important for AC21 if you are traveling. Having it while you are inside USA is irrelevant. Star 5 if you have a follow-up question. Amit wants to know, I'm a green card holder, how can I bring my mother here? And I actually did a consultation on this today, and I explained to folks that sometimes, under certain circumstances, if your close family members don't qualify for derivative status, for example, H4 is only available for spouse and children. What about parents? Government might allow ongoing rolling 6-monthly extensions of tourist status. So if there is a reason for that, that might be possible. So the consultation I did today, the parent was 65 years old and they have health issues, and the children are on green card. So can they get their father here? And the answer is yes, but that provision is really a policy matter. And if Trump administration wants to change the policy overnight, they will. But we have many cases where tourist visa is being extended or tourist status is being extended on a rolling 6-monthly basis now for many years. Star 5 if you have a follow-up question on this. Star 5. Okay. This one is from California. Yeah, California, go ahead please. I can hear you.
Hello. Hi, good afternoon, Rajiv ji. This is Amit Surve.
Hello, Amit.
Actually, I missed the first part of the conversation. I actually joined the call late because of my meeting here. When you given the suggestion on the tourist visa. So unfortunately, my father expired 6 months back. I'm on green card. And it's not easy for us to relocate back to India. And then I would like my mother to be present with us for a longer duration rather than just 6 months of B2 visa.
Yeah, you should listen to the recording, Mr. Survey, and you will hear me say that a tourist visa can, under certain circumstances, be extended. If you look at the State Department Standard Operating Procedures, which are contained in a document called Foreign Affairs Manual, you will see that I think it's volume 9, and I think it's note 42. So under 9 Foreign Affairs Manual, you will see there is a category of tourist visas which is available for people in your mother's situation. It's not guaranteed to work, but it should. Okay?
Okay, so it's a different type of visa. It's not just a visitor's visa.
It is a visitor's visa. It's just extended based upon special circumstances.
Okay, and then the rolling extension, is it almost like a limitless? It can go for like 2 or 3 years?
Yeah, I've had, the most I've done is I think 5 or 6 years, still going.
Okay.
I can't hear you, sir. I have no idea what you said.
Oh, okay, but then you can stay here. Okay, and okay, thank you, Rajiv.
You're welcome.
Appreciate it.
You're welcome. Okay, guys, I have about 5 or 10 minutes for any new questions. Press *5. If you have any question, press *5. So, let's see. We have only one question. Okay, that's easy. This is from Florida. So, Florida, go ahead, please. Oh, there's another one. Okay, Florida.
Yes, so I have one question. Yes, I have one question in relation to the extension of stay on B2 visa. That I asked for, say I asked for 4 months. Is it sure that if they approve, they will give me 4 months, or they can give me shorter duration than that as well?
They can give you shorter duration. Normally, they'll give you what you ask for if you have asked, if they are going to approve it. So normally they'll give you whatever you asked for, as long as it's 6 months or less. Okay.
Time, then I would have accrued unlawful presence, right?
You were actually cut off in the middle. All I heard was accrued unlawful presence. What do you mean?
So, suppose I ask for 4 months, but I get the decision after I have left, and they approved it only for 3 months. But in that case, I would have like overstayed 1 month, right, which was considered unlawful.
There are a couple of things you need to remember. One, unlawful presence of less than 180 days is no permanent problem. It can be a problem for your future tourist visas. Only unlawful presence becomes a major issue only upon 180 days. Number 2, this is not really unlawful presence because you were in the US waiting for a good faith application to be decided. That's called authorized period of stay. That's not unlawful presence, even if they cut it down to 3 months. Okay? That's not unlawful presence.
Okay. And does it in any case, cause any problem to me in future in my H1Bs or green card, or these are like completely separate things?
No, these are separate things. Unless you have done something illegal, it doesn't affect you.
Okay, and just one last question. So my mother, even in her earlier trip, like she left 2 months back, she left in December, she came back in February. So does this like damage my case that she had 2 frequent visits and I'm asking for an extension?
Does it damage your case? I don't see how it damages your case, but it doesn't look good for her if she's coming back so frequently. That's not good.
Okay.
Okay.
Okay, thank you.
Good luck.
Yeah, and in this case, would you recommend going to an attorney for the extension, or I can do it on my own?
I don't see what the attorney is going to do as long as you tell the truth.
Okay. Okay, thank you so much.
You're welcome. Okay, let's go to, we have 2 more people. One from North Carolina, one from California. North Carolina, go ahead please. North Carolina.
Hello, sir. Sorry, I couldn't able to ask follow-up questions on the F1 to green card.
All right.
So it's on that one, sir.
Sure.
Sir, actually, our company have another branch, our head office is in UK. Okay. So that was, I showed my HR manager who's handling this case. I told him, like, look, because I'm from India, it takes like 2045, even if we file in EB2.
Yeah.
So he was asking, I head the department, but my designation is lead. What if if they change my designation? Will I be still somewhat like, is it possible, or I should go to UK, stay there once?
Oh, absolutely. Absolutely. If you have the choice of being a manager and be outside USA for 1 year, it's a great way to go. They don't have to change the designation right now, but once you go to UK, you should be a managerial person. I would strongly recommend you consult with a lawyer, show them the job description that you are planning. Plan for 1 year ahead. We have plenty of people who are doing it with us. So it's always a good idea to plan ahead of time. And definitely that's a very good way to go. Okay.
Okay, so but even if it is an EB1 and I can't do it staying in US, like now I have another 8 months of my validity.
You cannot. Only EB1A doesn't care where you live. EB1C requires you to be outside USA for 1 year. Okay.
Okay, sir. Thank you so much, sir.
You're welcome. Good luck. Last one is California. California, go ahead, please.
Yeah, Rajiv, this is Amit again about my mother. We talked about the rolling visa. Now I'm in my third year of green card, and in 2 years I'll be eligible for citizenship.
Right.
And my long-term plan is like after I get citizenship, I file for my mother's green card.
Sure.
But now in this 2 to 3 years time period, from now until that point, if I go for, say, multiple rolling visas, extensions, would that affect my mother's green card
No.
applications?
No. As long as you don't lie about anything, as long as you are truthful in your presentation, remember that if your mother stays in the US unlawfully for 2 years, then you become citizen and apply for her green card. She will get her green card even though she's unlawfully present for 2, 20, 30 years, as long as she doesn't travel until she gets the green card. So yeah, she's protected from several angles.
Okay. Second quick question on that. That falls under the same B2 visa stay extension, right? You just have to give the proper reasoning, like why you want to extend or stay here.
I would not recommend you do it yourself. Get yourself a lawyer.
Okay, I will contact you then in that case. And the third question, last question is, say, if we apply for the extension, this time I've applied for the extension with that 529 form. What if we get denial, but then in meanwhile, I've applied for a tourist visa for her for Canada. So if we get denial for that, and then if we make a trip of 1 or 2 weeks to Canada, come back to US, would she get a new I-94?
Normally, no.
Normally, no. Okay.
All right.
Okay. Thank you so much, Rajivji. I'll contact through Jenny or your secretary to schedule a 15 minutes of consultation on the rolling.
No problem at all. Good luck, sir.
Thank you so much.
All right. Bye-bye. I think I've answered everybody's questions. I did Sunnyvale, California. I did Florida, North Carolina. Yes, everybody's been answered. All right, folks, it's good talking with you, and I will see you again in 2 weeks. Thank you for your time. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.